Hello, my name is Faisal Fasi. I teach in West Bengal National University of Juridical Sciences, that is NUJS. The topic is inchoate offence. So, first we will look at what the meaning of the term inchoate offence. There are two elements of crime, as you know. One is actus reus, that is the act or omission, and mens rea, that is guilty or malified intention. So, generally crime is said to be committed only when a particular result takes place, such as for the offence of say murder, there should be a death of a human being, right. So, if a victim survives even after a brutal assault, somehow miraculously if a victim survives, it would not qualify for the murder, but the offender will be charged for attempt to murder. So, what we understand from here is in case of survival of victim, the intended mens rea or the result is incomplete, right. So, this is technically called the offence of inchoate crime or inchoate offence. Apart from attempt to commit an offence, the other cases of inchoate crime are number 1, criminal conspiracy and abatement, right. So, in total we are having 3. Now, coming to the test of understanding attempt, crime consists of 4 successive and distinct stages, namely number 1, formation of guilty intention, that is technically mens rea, second, preparation, third, attempt, and finally commission. Mens rea, the first stage, is the mental element of an offence, is never punishable because it is almost impossible to check the heart and mind of the person, right. Preparation includes arranging means and measure to execute the intention and is generally not punishable because of at least 4 reasons. Number 1, it is very difficult to prove that the person will commit the act, right. For example, suppose Mr. X purchased a knife with the intention to kill Mr. Y. At this stage, if he is arrested on mere suspicion, so what is going to happen? He may justify that he purchased the knife for cutting vegetable. Thus, there is a possibility of more than one hypothesis. Number 2, remoteness between intention and preparation, right. Number 3, no disturbance is caused to the public peace, and the last one, likelihood of harassment to the innocent people, right. However, preparation is punishable in at least 3 kinds of offences, namely number 1, offences against the state such as waging war against the state, number 2, possessions crimes such as relating to counterfeit currency, and number 3, dacoity. So, in these 3 cases attempt may be punishable. Attempt is actually nothing but a failed commission, while commission can be called as successful attempt. All commission is attempt, but not vice versa. Attempt is always punishable because the guilt of the offender remains same as in commission. It also creates an alarm in the society, which by itself is an injury. In this backdrop, one may argue that successful attempt is the aim or mens rea of the offender, not an unsuccessful one. So, from the point of view of intention of the offenders, attempt is incomplete, hence it may be qualified as inchoate offence. The law of attempt lacks clarity due to lack of precise definition, considerable variation in elements of crime, and inconsistency in precedents among other things. There is a very thin line of difference between preparation and attempt, and each case has to be decided on ad hoc on the basis of the given facts because law does not provide a concrete definition of either of the concepts. So, the main issue here is to study the guidelines for differentiating attempt with preparation. There are several tests which attempts to actually attempt or to explain attempt of an offence. The prominent among those are impossibility test and proximity test. Regarding impossibility test, it signifies that offender may be held liable for attempt even if he tries to commit a crime which is beyond his capacity or expertise, or situation is such which it is not possible to achieve the desired goal. Impossibility may be of 2 types, it may be factual or legal. For example, if a person tries to open a high security locker by using a tool by which it is not possible to break the lock, or he wanted to commit theft, put his hand into the pocket of someone but finds nothing. In both the situation, he will be charged for an attempt, even though factually it was not possible for him to execute the crime. The case of R versus Shivpuri is relevant here. The accused in this case visited India and was approached by an Indian citizen who offered to pay him £1,000 for receiving a particular suitcase from a courier on his way back to England, and he was supposed to deliver the content as per the instruction given to him. So he collected the suitcase and was arrested by the police while he was delivering the packet to the third party after receiving an instruction. During interrogation, he confessed his role as a recipient and distributor of illegally imported drugs. The sample was tested in the laboratory, but to the surprise of everyone, it was found that the substance was not controlled drugs, rather it was some harmful vegetable matter. So, the accused was held liable for dealing in illegal drugs. Over here, the crucial aspect is the belief of the person and the intention preceding his action to do a particular act. In other words, personal knowledge or expertise is irrelevant. On the other hand, if we talk about legal impossibility, it arises when the offence cannot be completed due to legal implications. For example, if I have the mens rea for conversion of property, say there are several black umbrellas in one room and I own one of them, but mine is not in a very good condition. So I wanted to take the umbrella of someone else. So what I will do is I will keep the mark of the place where I kept my own umbrella. Now imagine that someone has shifted my umbrella to some other place and I enter the room with the intention of picking good umbrella. So I will not pick from the place where I had not kept mine. However, since rather I will pick from the place where I have not kept mine, so unfortunately my umbrella was shifted to some other place. So what happened in this situation? Suppose I pick up my own umbrella by mistake, I may be charged for an attempt. Second test is proximity test. According to it, an action or omission must be proximate and not too remote to the accomplishment of the desired consequences. In simple words, there should be a direct nexus between the act and the consequence. A case of Abhayanand Mishra versus State of Bihar is the leading case on the point. What happened in the case, the accused falsely represented himself as a graduate and applied in the university for the postgraduate examination by attaching fake certificates. The university accepted the document and gave him the permission to take exam after emission of examination fee. The accused submitted the fee along with his photographs and the university issued the admit card. Later on, the university came to know about the fake documents. He was charged for the offence of cheating. One of the contentions of the defence was that the act of applying for exam was the stage of preparation because the applicant never attempted to take the exam. The accused was held liable for an attempt to cheat. The court explained that attempt need not be the penultimate act before the actual commission of the offence. A person may be charged for attempt if he has met preparation with the intention of committing an offence, followed by an act towards its commission. The court emphasized that the determination of attempt to commit an offence is a question of fact. There are several other tests. So a few of the tests are for separating preparation with attempt. The popular one are number 1, doctrine of repentance, number 2, equivocality test, and the third one is social danger test. Regarding doctrine of repentance, it denotes that a person will not be charged for an attempt if he is in position to give up or abandon his plan out of his own accord after the formation of mens rea. It was applied in the case of Malkyas Singh versus the state of Punjab, 1970 case. In this case, a truck carrying illegal goods was driven in Punjab-Delhi highway and was stopped by the police at 14 miles from the border. The Supreme Court acquitted the accused and explained the difference between preparation and attempt. The court stated that if the act done by a person is harmless and if he is in position to change his mind and do not proceed further, would not qualify for an attempt. However, in the subsequent cases, the court changed its stand and hold offender liable in similar kind of situation. Now coming to equivocality test, it suggests that an act is considered as attempt if it indicates beyond reasonable doubt the end result is towards what to which it is directed. It is actually a continuation of the rule of proximity. Glanville William has explained it in the following words, to quote, "It is as though a cinematographic film which has so far depicted merely the accused person's act without stating what was his intention has been suddenly stopped and the audience were asked to say to what end those acts were directed. If there is only one reasonable answer to this question, then the accused has done what amounts to an attempt, and to attain that end, If there is more than one reasonably possible answer, then the accused has not done enough. End of quote. Finally, social danger test is often applied by court in dealing with borderline cases of preparation versus attempt. This theory considers the seriousness of the crime in question and its ramification in the society. In the case of State of Maharashtra versus Mohammad Yaqub 1980 case, the court took the economic impact into consideration and said that strict interpretation should be done because illegal smuggling has huge negative impact in the economy of the country. Similarly, a strict approach has been followed by court in cases relating to vulnerable groups such as women and children, adulteration of food and terror activities. The court in India have not decided the case by applying one or the other rule. The general practice of the court is to use proximity rule along with other tests if at all applicable. Now, treatment of attempt under IPC. IPC deals with attempt in 4 different ways. First, commission and attempt are dealt by the same provision and punishment for the both is same as in cases relating to offences against offences against the state. Second, separate punishment is provided for attempt as in case of attempt to commit murder. Third, only attempt is punishable and there is just one case, that is attempt to commit suicide. Fourth, an attempt is punishable under section 511 if a specific provision is not provided. Now, coming to second, criminal conspiracy, the second category of inchoate offence. So, conspiracy is an act or process by which 2 or more persons execute secret agreement or plot to carry out an illegal act. So, mere agreement is punishable here. Given that for convicting a person for an offence, 2 elements are required. Number 1, actus reus, that is act or omission punishable by criminal law, and mens rea, that is guilty intention. One may wonder at this stage why mere conspiracy is considered as offence in the first place, as it appears from the general understanding that mere intention is punished. This issue was raised long time back in the case of House of Lord, that is a case of R versus Mulkey or Mulkey versus R. The court explained that when 2 or more persons agree to give effect to an intention, the very plot itself is an act. Again, we quote Glanville William. He suggested that law is fearful of number of people involved in planning. So, William is trying to differentiate a situation where only one person forms a mens rea for committing an offence and where several people develop mens rea and also share among themselves. It may provide an impetus or momentum to carry on the act intended. Section 120A of IPC defines criminal conspiracy as when 2 or more persons agree to do or cause to be done an illegal act or an act which is not illegal by illegal means. Such agreement is designated as criminal conspiracy. It is provided that no agreement except an agreement to commit an offence shall amount to criminal conspiracy unless some act beside the agreement is done by one or more parties to such conspiracy thereof. It is important to note the implication of the term illegal. As per section 43 of the Indian Penal Code, illegal includes offence, civil wrong and any other kind of wrong for which action may be taken in the court of law. Thus, criminal conspiracy includes conspiracy to commit civil wrong. It is further clarified in the explanation that it is immaterial whether the illegal act is the ultimate object of such agreement or it is merely incidental to that particular object. Now, coming to the features of criminal conspiracy, I have divided into 5 categories. Number 1, there should be an agreement. Agreement simply means 2 or more persons having consensus on something. In the context of conspiracy, the conspirators should have consensus over one of the 2 things. Number 1, either illegal act or illegal means to perform legal act. Unlawful agreement rather than the manner of accomplishment is the essence of the offence. Now, agreement may be express or it may be implied. Express agreement is either oral communication or in written form, whereas implied depends on the conduct of the person. Since it is almost impossible to find express agreement to conspire, most of the cases of conspiracy are decided on the basis of circumstantial evidence, and hence it is important to understand implied agreement. In this context, the challenge for the court of law is to differentiate a case of mere knowledge with a case of agreement or consent. The latter is an offence, but former is not. In other words, mere knowledge of the conspiracy is not sufficient, but one should consent to the plan. Now, take an example. Say X and Y were conspiring to kill Q, and Z knew the plan, but did not respond in any manner. X and Y will be held liable for conspiracy because they consented to the act of killing, but Z will not be prosecuted because he only knew about the conspiracy but never gave his consent. But imagine that X and Y were on the way to kill Q, and Z, having knowledge of it, accompanied them, may be held liable for conspiracy. Similarly, Z may be charged for conspiracy if he supplies gun to X and Y in the above situation. Now coming to second point, continuing offence. In criminal conspiracy, series of act is considered as one single act. Suppose conspirator conducted 5 meetings and discussed on different agendas. All the 5 meetings and their agendas are considered as one particular conspiracy. Further, it is not essential that all conspirators must agree to illegal act at the same time. In fact, the joining of new members in conspiracy does not change the status of the existing conspiracy. Now take an example. X and Y conspired to commit an offence and discuss the modus operandi of crime on 3 different occasions. Z, another person, joined on the 4th discussion. All the 4 discussion would be considered as one, and Z would be responsible for the entire plan, even though he joined later on. Third point about conspiracy is it is based on mutual agency. So mutual agency or joint agency you can call. Thus, everything said or done by one conspirator in furtherance of common object is deemed to be said or done by all conspirators. The liability is not confined to the original goal, but extend to all incidental and collateral incident arising out of the main goal, because everyone is presumed to know the natural and probable consequences of his conduct. However, a conspirator may not be held responsible for unlawful acts done after the accomplishment of the object, right? For example, X and Y conspired to kill Z and hired C, a contract killer. Now C killed Z and M provided food and shelter to C after he committed murder. M will not be held responsible for conspiracy of murder. Fourth point is method of proof. There are 2 ways to prove a criminal case. One is by direct evidence and other is by circumstantial evidence. Since conspiracy takes place in privacy, it is almost impossible to get direct evidence for proving conspiracy. So conspiracy is generally inferred from the circumstances. Circumstantial evidence is based on the premise that there should be only one possible hypothesis, and that hypothesis should point toward the guilt of the person. Now the last point regarding conspiracy is that criminal conspiracy is a substantive offence in the IPC and also a form of abatement. In certain cases, conspiracy has been dealt separately, such as in offence relating to waging war against the state. An issue arose in a case, rather in several occasions, whether one person can be convicted for conspiracy. As mentioned earlier, minimum 2 persons are required to conspire. One cannot conspire with himself. However, one person may be convicted in certain cases, such as the other accused has been pardoned or dies during the pendency of the appeal from conviction, right? Now coming to the third category, that is abatement. Abatement is the third type of inchoate offence. In common parlance, abatement denotes an act or process of inducement, encouragement, assistance or command for the purpose of commission of an offence. The Indian Penal Code classified abatement into 3 categories. Number 1, instigation. Number 2, conspiracy, and finally aid. So starting with abatement by instigation, in a literal sense, the word instigate means to provoke or stimulate. So abatement by instigation may be defined as an act by which one person, that is abater, provokes another person, that is abated person, to commit an offence. The victim may be anyone, it may be third party or the abated himself. A typical example of abated person being a victim is a situation of abatement of suicide. The determination of instigation is a question of fact. Instigation may be done by performing an act or omission. An example of act could be where X encourages Y through several rounds of communication to cause injury to Z by convincing him that Z is a bad person. On the other hand, a case of omission arises where a person is acting under obligation, or rather under an obligation to act, but he remains indifferent and allows an event or thing to take place or continue. Now take an example. Say a policeman is under an obligation to prevent crime, but in spite of having knowledge of crime, if he doesn't act, he may be held liable for abatement by omission. However, if a person is a mere spectator when the crime takes place, may not be held responsible because he is not having any obligation unless he takes some active part in the commission of an offence. Second category of abatement is abatement by conspiracy. in criminal conspiracy, mere agreement to commit an illegal act is considered as substantive offence, right. But in abatement by conspiracy, some overt acts are required after the formation of an agreement to conspire. Now, the last category of abatement is abatement by aid. A person commits an offence of abatement by aid if he intentionally provides assistance in the commission of the crime by an act, omission, or facilitating the commission of an offence. Abater must perform some active role. For example, X and Y are fighting and Z puts knife in the hand of X during the heat of the moment. Z may be held liable for abatement by aid if X stabs Y with the knife. Situation where abatement takes place. Number 1, abatement of an illegal offence. The abatement of an illegal omission may qualify for an offence even if the abater is not bound under the law. For example, X and Y were involved in fighting in a public place, which is an offence of affray. Now, policemen arrived in the scene and it is their duty to prevent crime, right. However, Z instigated policemen to leave the scene, and acting on such instigation, they actually left the place. Policemen may be held guilty of illegal omission for violation of their duty, and Z, even though he was not bound to prevent crime, will be held liable for abating illegal omission of the policeman. Second category is act abated need not be committed. So, abatement is a substantive offence. Abater will be held liable even if the abated person does not commit or refuses to commit an offence in pursuance of the abatement. To take an example, X say instigates Y to kill Z, but Y does not attempt to kill Z or refuses to carry on the act. X will be held liable for abating or abatement by instigation. Moreover, in the above example, if Y shoots the victim, but the victim recovers from the injury, then X will be held responsible for abatement of murder. Thus, for convicting a person for abatement, desired result need not take place. However, the consequences of the abated act are relevant for the sentencing policy. Third category is abated person may be incompetent to commit crime. That means it is not essential that the abated person must be capable to commit an abated offence, such as a child below 7 years is entitled for complete immunity from criminal liability. For example, say X gives a poison to Y, a child of 6 years, for mixing in the food of Z. Although Y is not competent to commit the offence, X will be held responsible. Now, whether Y administer poison in the food of Z or not, it does not matter. Further, it is not necessary that the abated person should have the same mens rea as the abater. For example, A intending to cause a theft to be committed, instigate B to take property belonging to Z out of Z possession. A induces B to believe that the property belongs to A. B takes the property out of Z possession in good faith, believing it to be A's property. Now, B acting under the misconception does not take dishonestly and therefore does not commit any offence, but A is guilty of abating theft and is liable to be punished for the same, as if B had committed the offence of theft. Point number 4, abatement of an abatement. An abatement of the abatement to commit an offence is also an offence. For example, A instigates B to instigate C to murder D. B in pursuance of it instigates C to kill D. C kills D. Both A and B will be liable for the same punishment. Number 5, abater need not consult with the abated person. In the case of abatement by conspiracy, the abater need not enter into an agreement with the abated person. The engagement of abater in conspiracy is sufficient to convict him. For example, X conspired with Y to kill Z by poisoning, and it was agreed that X would administer the poison. Later on, Y explained that they planned to say some other person, Mr. P, and mentioned that the third person would administer the poison in the food of Z, but did not disclose the identity of X. P procured the poison and gave it to Mr. Y. X mixed the poison in the food of Z and the latter died after consuming the food. Although X and P did not conspire together, yet P had been engaged in abatement by conspiracy and hence committed the offence of abatement of murder. The next point is abatement taking place in India for offence committed outside India. A person would be guilty of an abatement of an offence if he abates the offence in India, but the act would be committed outside India. Now, to take an example, X is liable for abatement if he abates why in India to commit an offence in Pakistan. To summarize, in inchoate crime, all the requirements of offence are not fulfilled, yet the actor is punished. It arises in three situations, namely attempt, conspiracy and abatement. A person is punished for an attempt when he has taken any steps, mind you any steps after preparation which is proximately connected with the commission of crime. Conspiracy deals with an exchange of common mens rea between two or more persons. Finally, abatement covers various scenarios where one person influences the other person via instigation, conspiracy or aid. Thank you for listening.